I don't think there was much difference. We really highlighted and focused on the question of, did the SDC know about the timing in the MTA agreement? Were they aware of the time frame going out to 2030? And we pointed out that none of the record sites presented by ESDC supported their argument. The ESDC board was not informed of the 2030 date, period.
Well, they said actually that some of the people commenting at the public meeting mentioned it, some of, I assume, opponents of the project.
Right, and we put it in our letter. I mean, it's in the comment letters, but the fact is it was not found, the ESDC board did not read the comment letters. Right. They got a staff summary which never mentioned it. And it was not included in everything. So unless the ESDC board members are going through the record with a fine-tooth comb and reading everything, which of course they didn't, nor are they expected to, they had no way of knowing. And you don't simply say they knew about such a material fact by hiding it somewhere in the record. That's something staff should have highlighted. Hey, this is a major change, you need to know about this.
So there was a conversation about the 25 years being 22 years, either one of those being the outside date for construction. And the ESDC has a development agreement that's going to compel Farsi Redner to build this thing faster.
Well,
and they said
supposedly.
Right.
Nobody's seen that agreement, and nor did they clearly say that it's actually going to make them do that.
Right. So how can they talk about a development agreement that doesn't actually exist, or it doesn't exist publicly? I mean, that's what I wrote.
Well, and we raised that. We said that it should not, the court should not consider that as part of the basis for affirming what the ESDC board did in September 2009, because these supposed promises were not clearly articulated and did not exist. Now, if they want to produce the development agreement and have a hearing on the development agreement, we'll do that. But I don't believe there is a master development agreement that covers Phase 2. They didn't clearly say that there is one. And I don't believe it's got any kind of a real binding commitments to assure that Phase 2 gets built anywhere near 2019.
You say you foiled for that development?
Yes.
And as did I.
And they had said they would get back to me on its availability last Thursday, and I haven't heard back yet.
So you filed for a preliminary injunction. The judge said she wasn't going to roll it because she was going to roll it. What's the purpose of the preliminary injunction?
We have to ask for a preliminary injunction to preserve our rights. The courts say if you don't ask for a preliminary injunction, even though it's a timely lawsuit and the project goes forward to the extent of substantial completion, even if we win, our victory could be mooted out. So to preserve our rights, we have to ask for the preliminary injunction.
So what happens if you do?
If we do win, it annuls the general project plan of 2009 and the subsequent resolutions and contracts that were issued. I imagine we'll have arguments with the SDC and FCRC as to the extent of that, but I'll worry about that later.
Anything you wanted to add?
I think the judge gave us a lot of time. She was familiar with the papers, familiar with the project and the case. We certainly got a fair hearing, and we trust that she'll give it careful consideration.